the right to privacy, the right to marry, to send your children to private schools, to live together with your family members, and states' rights. What do all these things have in common? They aren't in the Constitution, not in the words of it anyway. They are in the Constitution according to Supreme Court interpretation. But is that justified? What business does the Supreme Court have saying that the Constitution contains rights that, if you look at the words, it doesn't? There's no one agreed upon answer to that question. What I want to do today is tell you how the Supreme Court answers it, which, to be honest, isn't all that well, and then to suggest a slightly different rationale. What the Supreme Court currently says, and I mentioned this back in week 3, is that the Due Process Clause protects fundamental rights. But how does that work? How do you know if a right is fundamental? Well, being listed in the Constitution is a pretty good hint. So, there's a Due Process Clause in the 14th Amendment, which talks about the states. And one thing that clause does is to take the Bill of Rights, almost all of it, and allow you to assert those rights against the states. The original Bill of Rights, remember, only gave you rights against the federal government. This process of incorporation is what we were just talking about last time with the Second Amendment. But does this make sense? Due process is about procedure, some people say. It's about how the government goes about doing things. But these are substantive rights. They're about what the government can and can't do, not about how. Substantive due process, some people say, makes no sense at all. It's an oxymoron, a self-contradiction, like jumbo shrimp. There's an answer to that objection, which is that the Supreme Court is doing the right thing, but using the wrong constitutional provision. The 14th Amendment gives 3 different kinds of protection. It says states can't take away life, liberty, or property without due process. That's the Due Process Clause. And that they can't deny people equal protection. There are a lot of cases about those 2 clauses, and we'll talk about them a fair amount. But there's another clause that people don't talk about so much. It says no state shall make or enforce any law that abridges the privileges or immunities of citizens of the United States. This privileges or immunities clause probably sounds pretty important to you. It probably sounds like it does protect some substantive rights. Privileges or immunities is a pretty good way of describing rights. Better than due process, anyway. And there's pretty good historical evidence that the Reconstruction Congress, the people who wrote the Privileges or Immunities Clause, did intend it to protect some rights, including the Bill of Rights provisions. But the Supreme Court said no. In a case decided soon after the Civil War, it said that the Privileges or Immunities Clause means basically nothing. And ever since then, despite arguments from a lot of different people, from a lot of different political perspectives, the clause has been dead words. The Supreme Court isn't willing to look back and consider whether it made a mistake, even though most people, liberals and conservatives alike, think it did. Now, one reason the court hasn't done that is that it's doing basically the same thing. It's protecting basically the same rights under the Due Process Clause. So maybe it doesn't matter all that much now. Except that maybe if the Supreme Court said it's the Privileges and Immunities Clause that protects these rights, people wouldn't say, wait, substantive due process, that's like jumbo shrimp. But substantive due process also protects other things. The right to use contraception, for instance, the right to abortion, the right to have children if you want, and to be recognized as their parent. These aren't in the Bill of Rights, or anywhere else in the Constitution. So now there's another question. Where do those rights come from? The Supreme Court has never really answered that. But it turns out that the Constitution does say something about it. The 9th Amendment, part of the Bill of Rights, says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. The 9th Amendment was designed to answer one objection to a Bill of Rights, which was that if some rights were written down, the government might claim that no other rights existed. Other rights do exist, the 9th Amendment says. Don't deny them. And the fact that they haven't been written down doesn't make them any less important. Don't disparage them either. So again, the practice of enforcing rights that aren't there in the words of the Constitution can actually be justified by reference to those words. But we still have a pretty hard question. Even if you agree that the 9th Amendment means that these rights exist, and that judges should enforce them, and those are 2 different questions, How do you identify them? Here, the Supreme Court hasn't been able to settle on an approach. Sometimes they say, we will protect rights that are deeply rooted in our nation's history and tradition. And sometimes they say basically, we will protect whatever we think is important enough. There's no perfect answer. That's the one thing that everyone seems to be able to agree on. So what I've said so far is this. The Supreme Court protects individual rights that aren't listed in the Constitution. It does this under the Due Process Clause, which makes the whole project look a little less sensible than it might if the court said this is based on the Privileges or Immunities Clause and the Ninth Amendment. But in any case, there's a genuinely hard question about how to identify those rights, and the court can't agree on the answer. Now, what about states' rights? You hear a fair amount about states' rights sometimes. When the federal government is doing things that people don't like, one of the arguments against it is usually something about states' rights. But what are these rights? The Constitution actually has very little to say about states' rights. It says that no state can be deprived of its 2 senators, and no state can be forced to give up territory without its consent. But when people talk about states' rights, they tend to point not to those provisions, but to the 10th Amendment. That says that the powers not delegated to the federal government or prohibited to the states are reserved to the states or the people. The Supreme Court has at times relied on this as a source of states' rights. The federal government can't control the wages that states pay their employees, it once said, or the hours that they work. Some essential state functions, it said, are immune from federal regulation. But it only said this for about 10 years, from 1974 to 1985. In 1985, it gave up on the idea of states' rights in the form of these immunities. Why? Because it couldn't figure out which states' rights were important enough to protect. So there's an interesting comparison to make here between individual rights, which sometimes get protected even though they aren't in the words of the Constitution, and states' rights, which generally don't. It's interesting to think about whether the court is wrong in treating them differently in this way. And one thing to think about there is whether states' rights and individual rights are different in important ways. Now, some people say individual rights are more important. They're valuable in and of themselves. States' rights are valuable only to the extent that they make individuals better off. The Constitution is there for the benefit of we the people, not we the states. And other people say no. The states are sovereigns within our constitutional system. Their dignity is important. Their rights matter in and of themselves. Here's something else to think about. The 10th Amendment doesn't actually say anything about rights. The Ninth Amendment does. It is about individual rights. But the 10th Amendment is about state powers, not states' rights. And what the Supreme Court has done more recently, in terms of protecting states, has to do with powers, not rights. In a couple of recent cases, the court has said that the federal government can't make the states use their powers. It can't make state legislatures pass a law, or state officials enforce a federal law. The federal government can't commandeer the states. This is an approach that works pretty well with the words of the 10th Amendment. It says the powers of the states belong to the states. They aren't there for the federal government to use whenever it wants. So, the states, the federal government, the people. Those are the players in our constitutional system. We've seen how they interact in some specific ways in the past few classes, with the Second Amendment and now the Ninth and 10th Amendments. And next time, we're going to talk a little about how they relate more generally. In particular, how have their relations changed over the years?